Good morning, everyone, and welcome to today's webinar to all our participants from across the world and also those listening to this recording. My name is Vijay, and I am the UNICEF Global Focal Point on children's access to justice at UNICEF. This is a second webinar in a series co-hosted by UNICEF and the International Association of Youth and Family Judges and Magistrates. And today's webinar is about sharing experiences on keeping courts operational for women and children during the pandemic. Today's webinar will involve questions to our distinguished group of panelists. They won't be making presentations per se. However, any presentations or publications that they refer to, we will provide links to later. We are also recording this webinar, and it will be uploaded online. During today's webinar, we'll receive your questions. In the bottom of the screen, there is a Q&A tab. So please click on there and type in your questions. And some of our panelists may choose to answer during the webinar. However, we will collect all the questions and provide written responses when we upload the recording as well. The Covid-19 pandemic has swept the globe into uncharted territory. With over 4.8 million cases and more than 320,000 deaths, the scale and the scope is breathtaking. In the wave of prevention measures across the globe, we saw many countries close or severely restrict the operation of their courts. And as we have seen, this had many implications for children and women, not least of all in respect of our first webinar, which was focused on the release of children from detention. And as we will hear today, these shutdowns or restrictions have had critical impacts for children and women across the world, and for many in terms of their safety. In today's webinar, we will hear from experts from 5 countries about how they have managed the disruption to the justice system and maintained continuity of court services for children and women. I'd like to now hand over to our panelists so that they can briefly introduce themselves.
So thank you very much, Viaha, for giving us this opportunity to share experiences on how some countries have dealt with the consequences of the pandemic and the children's access to justice. As for an introduction, I've been appointed as a judge at the Quebec court since 2009, after having been a lawyer, a legal aid lawyer representing children and women for 25 years. The Quebec court is a provincial court. It is composed of 3 chambers, the criminal one, the civil one, and the youth chamber, who deals with children in need of protection, juvenile in conflict with the law, and adoption. As for the family law matters, divorce, access, custody, this is a matter dealt with Superior Court. I'm sitting in the youth chamber in Sherbrooke, in a town of 200,000 people, a town located an hour and a half away from Montreal. Being in a small town has definitely been a plus for us because we know the stakeholders and it's easier to work together. And this has been paramount, I think, in our way to deal with the pandemic. As a youth court judge in March 2020, when this pandemic came into the radar of our country, it did not take long for me to understand that we would have to deal with tremendous challenges. At that time, I remembered an experience I had in Ghana, where I spent 2 years on a project on access to justice for women and children. And I remembered clearly again the commitment of lawyers and community organizers working together for years to try to give access to justice for women and children. So I thought I should roll up my sleeves and hold on to the challenge that I was facing, remembering that others have done it before me. And I think when we put everybody together, it really helps to solve the problem. So this is what we attempted to do.
Hello. First of all, I congratulate and express our thanks to UNICEF for organizing this webinar. I also use this opportunity to thank UNICEF Albania, but also UNICEF worldwide, about their mission and their work with children and women as well. I serve actually as Deputy Minister of Justice in Albania, and pre of this position, I've been part of civil society. Since 2007, I've worked in civil society which render legal service to people in need. I've worked as an attorney, providing legal aid to vulnerable groups, and I also had a chance to present strategic litigation in court in case of discrimination as part of civil society. In joining the Ministry of Justice, I was happy and also happy that I again get to work with vulnerable groups, women, children, and also people who need legal aid. The Ministry of Justice, in terms of legal aid, since 2008 has changed its legal system by providing primary and secondary legal aid to people in need. And most of the cases that we have in the Ministry of Justice are cases dealing with women in terms of property, in terms of domestic abuse, and so on. Moreover, as Deputy Minister of Justice, I also chair the mechanism for monitoring the juvenile justice strategy. In 2007, Albania adopted a very modern juvenile code that changed totally our approach towards minors, in a system that promoted restorative justice and the integration of minors in the social, cultural, and economic life, despite the fact that they may encounter crime during their way. And in 2008, we decided not only to have this juvenile code, have an interinstitutional strategy, which was coupled with a very detailed action plan with different measures. And this interinstitutional strategy, we include not only the Ministry of Justice, but the police, the prosecutor office, detention centers, and also civil society. And I'm very glad to have the position to chair the committee who monitors the strategy and also the action plan, and have channels of communication with different institutions and civil society with regards how the strategy is being implemented, its progress, its loopholes, and also possible changes in the future.
Greetings again to everybody. I'm Erion Moharemai, a member of the High Judicial Council of Albania, which is the constitutional organ responsible for the governance of the judiciary in Albania. And at the same time, I have the task of coordinating and monitoring the National Justice for Children strategy. I've had excellent collaboration with UNICEF before because I'm one of the members of the council coming from academia. Prior to this position, I have been a lecturer of public international law at the law faculty of the University of Tirana, just as Mrs. Tsaka. We've been colleagues there together. And part of it, of course, is the international protection of human rights, including rights of children, women, minorities, and so on. I've also been engaged previously in NGO work. I've been director of an NGO called European Center, which focuses on issues of human rights protection, of course, protecting vulnerable groups, as well as women and children. So thank you once again, and I look forward to offer my modest contribution to this panel. Thank you.
Hello, good morning. It's early in the morning in Brazil. My name is Eduardo Melo. It's a pleasure to be here. I'm also a member of the International Association of Youth and Family Judges and Magistrates, and I would like in this moment to express the joy of our organization with this partnership with UNICEF, and to thank UNICEF for leading this initiative in this challenging moment to share experiences with judges, magistrates, and legal professionals around the world. I'm a judge in Brazil since 1991. I'm sitting in a court in a medium-sized city in Brazil with a very specific structure. I deal with child protection issues, juvenile justice, crimes committed by adults against children, and domestic violence. Children's rights, especially when violence is committed within the family, is the main focus of these courts. I'm also a member of the Advisory Forum for the Child Protection and Juvenile Justice in the Brazilian National Council of Justice, which is presided by the Brazilian Supreme Court, which had also a central role in this moment. I have a PhD in human rights, being the pedagogical coordinator of the São Paulo State Judicial School. In Brazil, we have a special work regime since March the 19th. And since then, we may identify different stages on how the justice system has organized its services. An initial period of suspension of all procedural acts except those urgent. It was a period of organization, not only internally, but also an interaction between the justice system and the network of services dealing with children. And since May the 4th, we are in an exclusively remote work. It's a moment of analysis of impact of the remote work in each specific situation and case, especially when dealing with children. And we can foresee the beginning of a new moment when we prepare ourselves for a slow return to face-to-face acts with a series of conditions and the need to balance our daily work with sanitarian measures, but also considering and reflecting on what will remain from our current experience during this period of isolation. So I'm very glad to share our experience, to learn with my colleagues from other countries, and especially to help and to assist people from all over the world. Thank you very much for this opportunity.
Hello, good evening from Tokyo. My name is Mikiko Tani. I am very grateful for the organizers to organize this very important webinar. This is my great honor and a pleasure to be among the panelists to discuss this very important topic for children and women. I am currently a member of the United Nations Committee on the Rights of the Child since 2017. Also have been practicing law in the area of family law in Japan since 1990. Also, I have been serving as a family court mediator since 2003. Throughout my practice and my career as a practicing lawyer, I have been involved in the activities by the bar associations or by pro bono lawyers to address the issue of access to justice for women, children, and migrants. So today's topic is very close to my heart, and I'm very pleased to be given the opportunity to share some of my thoughts and experience in Japan. Thank you.
Hello, everybody. My name's Judy Ryan. I'm in here from Sydney, Australia. Unlike Brazil, where it's early in the morning, for me, it's very late at night. I'm a judge of appeal of the Family Court of Australia. Australia is a federation of states and territories, and our constitution divides judicial and legal work up between some areas that are the responsibility of the Commonwealth and some that is the responsibilities of the states. Private family law is governed by federal laws which apply uniformly across Australia. That's the work that I do as a judge of appeal. I hear the more complex cases that have already been decided at the trial level. Before I became a judge, some 20 years ago, I was the director of family law at Legal Aid, and that reflects my lifelong commitment to social justice, to promoting the needs for access to justice by socially and economically disadvantaged people, particularly women and children. And I'm just absolutely delighted, even though it is so late, to be able to join this wonderful discussion that I know we're going to have this evening about how we've all responded in this very extraordinary time of COVID.
We're very privileged to have two speakers today from Albania, as you heard. Albania is classified by the World Bank as an upper middle income country and works with many partners to strengthen its justice system for children and women, both domestic partners and international partners, including UNICEF and the EU, for example. Let's hear from the Deputy Minister and Mr. Muharremai about the ways Albania has kept the courts open for children and women.
Thank you very much. I'd start by saying that in terms of COVID-19, the general strategy of the government was to go into lockdown. And lockdown was seen as the best strategy, having into consideration our health system, the capacity of the health system, also the unclear way the virus was spreading. So since the midst of March, Albania went to a lockdown. And as Ministry of Justice, two of the priority sectors we had to deal with were the judicial system and also the penitentiary system. And we had difficult decision to make. In terms of court, one difficult decision to make was to have courts opened and continue business as usual, which on the other hand would affect the health of the citizens, clerks and judges, or going to a suspension of the court activities. Having into consideration that courts in Albania sometimes have very small spaces, having into consideration that court sessions sometimes are done into the specific rooms of the judges, and that there are not enough spaces or big rooms in the court, we decided to go with the suspension of court activities. And the suspension of court activities done at aiming certain objectives. First of all, the main objective of our normative act in suspension of court activities was how to attain access to justice, although we would suspend certain activities of the court. Suspension was important to preserve the health, but on the other hand, suspension was also important in terms of suspending specific deadlines and timelines in the Code of Procedures. We all know as lawyers, but I'm sure every citizen knows that whenever his or her right is infringed, you should claim your right into the court for within a specific deadline. And if you do not exercise your right in that specific deadline, that you cannot anymore claim that right into the court. And by going into a total lockdown, we understand that people have difficulties from going from one point to the other point, from one city to the other. And this could hamper their access to court and access to justice. So we decided that by a normative act, we shall suspend all the deadlines and the timelines for claiming a right before the court, in order that people could not lose the access to court after the pandemic was over. Also, in a special normative act which we enacted as a government, we decided that there would be specific cases which would not be suspended despite the pandemic. Special cases, for example, criminal cases where there is a urgent investigation, or when there is a need to secure evidence, or in cases, administrative or civil cases, a person would claim that his damage would be irreversible if he's not approaching court, then the judge should access him or her the right to be heard and also develop court activities as usual. Despite these specific cases for which the court were opened, we decided to give special access to women and children. If we go to the normative act, you can see that in case of family matter, such as maintenance or alimony obligation, cases of parental responsibility, cases of child custody or child adoption, should not be suspended, despite the general rule. On the other hand, we testified that during pandemic, domestic abuse was starting to be an issue. And that is why we decided that even cases of this domestic abuse shall not suspended, and everyone should have access to court in these cases. Special access should be given also to minors that are in conflict with law. Minors who had been in detention or arrested for crime that was prescribed in the juvenile code would have double safeguards. Not only they would access court at any time despite the pandemic, but they would have special procedural rights. For example, they can use telecommunication, they can use telephone, emails to communicate with the court and to speed up the appointment of a court session and also keep the channels of communication open with the court in order to have a ruling as soon as possible. Also, in terms of judicial processes involving minors and juvenile justice code, the session would be closed in terms of not having public or access to public in the room, but only to minors, his lawyers, his parents, or rather his close family. But we would reduce the number of people accessing court when a juvenile crime was at issue. Other provisions in our normative act regarding the suspension of courts was the possibility to have online court session. And this was a novelty of this normative act. Together with the High Judicial Council, and my colleague is here, and the penitentiary system and the Ministry of Justice, we decided to have an open door. Then whenever it was possible, we could have online court rulings, court session of the lawyer, of the accused, of the other parties that are present as procedural actors in a court session. And by having the court also opened with these tele-court sessions, we offered access, or tried to offer access to every citizen, especially women and children, despite the general rule of suspension or lockdown. Other measures which we took were also in the penitentiary system. We decided to release a number of detainees that had very few years left. For example, every detainee that has a charge and there are only 3 years left for him to suffer the charge, we would grant him or her the right to stay 3 months in his house, near to his family. And in these 3 months, he would suffer his own charge in his house, like a house arrest, I would call it. And during this time, he would, in terms of security, keep continuous communication with the police and also the detention center. But by releasing the detainees and providing them the opportunity to go in their home and have specific, let's say, health and also protection, we try to minimize all the possible spread of the virus in the penitentiary system. Moreover, in the penitentiary system, we took preventive measure to take care about the health of the prisoners and the inmates. We had set certain protocols that were able 24 hours in 24, like to measure time to time the temperature, to do medical control of the inmates, and whenever there was a sign, to decide for the release of the inmates and to bring him or her into the hospital. And of course, minors, most of them had few years left about this charge, would be the category who would profit from that. The last measure in the penitentiary system was also to have continuous and added telecommunication or telephone communication with the families. We were found into a situation where parents of minors were troubled and worried about the health of their children that were suffering a charge. And in order to release them of this burden and stress, and also to make the stress level less in the penitentiary system for the minors, but not only for every inmate in every prison, we decided to add up the number of phone calls they could make with family members and also to make Skype calls or video calls so they could see each other that are well and safe.
Thank you very much. It's a bit difficult to go on after such a comprehensive review by the Deputy Minister, but I would rather be speaking on a more practical note as to the measures that the Council and the courts have taken in order to facilitate the participation of especially vulnerable groups that are more heavily affected by the pandemic, as in other parts of the world. Upon the announcement of the emergency situation of COVID-19, we were aware that the complete lockdown would in fact expose the victims of domestic violence, particularly women and children, to additional risks. And therefore, they would continue to need the services of the court with a view to obtain legal protection. Also, we were aware that children deprived of liberty were at risk of infection from the coronavirus. So following the normative act that the Deputy Minister mentioned, we, as a council, issued on March the 10th a decision suspending all judicial procedures, with the exception of those that had a certain urgency, as it was indicated in the normative act. And the matter of urgency was to be decided by each individual judge on the present case that he had to hear. The council then proceeded with subsequent decisions, further stipulating the measures that had to be put in place by the courts to ensure continuation of rendering justice, particularly to women and children. And this includes the decision that we took to decide on using the Microsoft Teams as an online platform for the court hearings to be conducted. The district courts immediately reacted by issuing their own administrative acts, as it is a responsibility of each court's council to take such measures in order to allow for urgent sessions to take place, of course taking into consideration firstly issues of public health safety without putting in danger the safety of the parties. They organized the availability of judges in the criminal law, family law, and civil and commercial law sections in rotas, in shifts, according to a chart, according to which the judges would be ready to hear court sessions. To be honest, there were some difficulties in order to apply immediately the online hearings under the circumstances where some of the court computers were not equipped with webcams. But in general, courts are in the process of putting these in place, and we've had substantial help by two partners, the USAID and the European Union, that who through their projects assisting the council are helping for the courts to have the necessary equipment in order to facilitate these online hearings. In the special court against organized crime and corruption, where such a practice was put in place prior to the pandemic, they had experience on that, the online hearing of cases proceeded smoothly. Another challenge that I'd like to mention is the fact that particularly the most vulnerable groups, often the ones that are subject to violence and abuse, such as women and children, may not themselves possess the technology to meaningfully participate in the process. So we've had excellent collaboration with the Ministry of Justice and the detention facilities in order to provide the possibilities for the children as well to take in the online hearings. However, despite the fact that not all the facilities are in place yet, during the past 2 months in the District Court of Tirana, for example, which is the largest court in Albania, I got the statistics from them, and they have already reviewed in only that court 118 petitions for emergency protection orders against domestic violence, and 15 petitions for longer term protection orders. Similarly, this court, just like other courts throughout Albania, have reviewed cases of adoption, divorces, alimony, child support, removal of child from parental care as a protection measures, and cases of judicial validation of arrest measures or of replacement of custodial with non-custodial measures. I'd like to bring into your attention two illustrative cases that were held during this period of the pandemic. Last month, in April, the Tirana District Court ruled in favor of a plaintiff by validating the emergency protection order and by ordering the defendant to refrain from committing further acts of domestic violence and against the three children that the couple had, refrain from threatening, harassing, or contacting the plaintiff or the children themselves, to immediately evacuate the common residence and to be accompanied by state police forces to retrieve his personal belongings. He was ordered to refrain from coming closer than 200 meters from the victim, and to the mother it was granted the custody of the three children for the duration of the protection order. But on the other hand, in order to protect the father's rights as well, it was granted the right to him to see the children every Sunday between 10 a.m. and 4 p.m. Of course, it was an obligation for him as well to provide child support care for the three children at the amount of 40,000 lek.
Also pass over to Justice Gagnon in Canada to share the experience from Canada, please.
Thank you, Vieja. So as for the measures taken by our courts to ensure that the courts would continue operation during pandemic, as was describing Mrs. Chaka, mid-March, as the same thing in Canada, the Director of Public Health in each provinces in Canada, an independent body, recommended that the government close down almost everything except hospitals, and everybody should work from home. Or most of the cases most of the people were required to work from home. Following this announcement, the Court of Quebec decided to suspend all its activities except for a list of emergencies that the court would be dealing with. In the youth chamber, provisional measures involving children in need of protection were heard. Trials for children also in need of protections that were already entrusted to foster family or reception center on a provisional measures, because these measures cannot be longer than 60 days. So all these cases had to be dealt with. And every cases involving a young offenders that were detained and could get a chance to be released on bail or get a trial and be released because it would be found not guilty, or benefiting after a sentence and hearing of a release, all these cases were brought to court without exception. There were also some files that lawyers could file with in front of a judge by conference call to express that this file, although not in the emergencies specified by court, needed a specific attention, and that it would be to the judge to decide that this was considered an emergency, and that then put it on a docket to be filed and heard in a reasonable delay. So this we did. Of course, we were not sitting as much. We were sitting mainly for emergencies, so there was less court days, and at times we would add to hear all these specific cases. How did we do that to hear the parties? Well, the rule was, of course, that everyone should be heard outside of court to limit the contacts between the people in the courthouse, because as previously said, many courtrooms are very small, so we didn't want the court clerk, the judge, the people to be together. So how would we achieve that? So we put in place the web RTC, which is a bit of a team, and the video conference became the rule. And in small region like ours, very quickly lawyers started to use that, and very quickly we could do video conferences with the lawyers, avoiding people to come to court. But there were, of course, some parties that don't have the internet or the level of internet it requires to come. So we would reserve a room in the courthouse, very close to the door from the outside, where we put a video conference there so people could come into court, enter this video conference room and be heard in court, but not in the courtroom. And we would then access, their voice could be heard from the video conference. Sometimes they would come with their lawyer. Also, lawyers sometimes would ask their client to come to their office because they could respect the 2 meters distance, and they would have them on the video conference with them. Or if children was in a reception center, we would provide them with a video conference in the reception center, make sure there was confidentiality and neutrality, and would hear their voice through a video conference. We also tried the phone, but the phone has some aspect that we have to be aware of, is the confidentiality is not always there. People can register, so we were preoccupied by that, so we tried to avoid that. But of course, sometimes it's better to be heard than not to be heard, so we would make orders to protect confidentiality. But sincerely, sometimes I was not sure it was that respected, so we felt we should avoid that as much as possible. For the child in Quebec, to make sure that the voice was heard properly, the lawyer, every child has a lawyer and it's paid by legal aid, so lawyers would provide the court, would inform the court of how the child wanted to be heard. Was it by video conference, phone call, by his lawyer, by letter, by email, whatever means, we would trust the lawyer with a professional opinion that the child was capable to have his voice heard. As I told you, the neutrality of the place where he was heard was paramount. We were very concerned, preoccupied that he was not with the parents somewhere, with a foster family, in a neutral environment, to make sure we had, you know, what he really meant to say heard. And the confidentiality, again, the environment in which he was in had to be very confidential. So we make sure the debate didn't explode into the extended family, because for us it's very important that these family matters remain among us. We are now in the process of coming back to court. We are looking forward to that. We are putting plexiglasses in our small rooms. So we are intending in the next few weeks to kind of recuperate the rhythm, but there's a big backlog, and this is the challenges of the next weeks. So that's what I had to say.
Thank you so much, Justice Gagnon. Over to you, Judge Melo.
So in Brazil, from March the 19th until May the 4th, the National Council of Justice has suspended all procedural acts and has forbidden all face-to-face activity in the judiciary. Unfortunately, we haven't had governmental central coordination of all activities in Brazil. Central government has not taken the measures needed to make a lockdown, but local governments has taken these activities. And in most countries, in most states, like in mine, all activities were suspended. There has been a regulation by the National Council of Justice on how to proceed with emergency acts considered as habeas corpus and writ of mandamus to protect clear rights not protected by habeas corpus, pleas of injunction, pleas of release of any person deprived of liberty, pleas to arrest someone when they have committed crimes, and protective measures for children were one of the main concerns. All judges and professionals have worked in this spirit in a remote way. All files in Brazil are digital, which has attenuated the challenges, but we have also to create new alternatives on how to move the files forward. So the National Council has also recommended all judges to reanalyze the situation of people deprived of liberty and to avoid application of measures that would imply deprivation of liberty, both to adults and to juveniles. Many of them have been released, others that the procedures have moved and hearings have been made. It was easier when they were in the detention centers because there was internet access and it was possible to continue and to do the work. So it has been a great change in the way we have dealt with juveniles deprived of liberty. But there has also been a joint recommendation by the National Council of Justice, the Public Ministry, the public prosecutors, who in Brazil have also a civil role, with the Ministry of Social Development regarding the situation of children deprived of parental care who are in institutions because of the concern of contamination. Unfortunately, institutions still prevail in Brazil when alternative care is at stake. Judges had to anticipate evaluation of those children to analyze if it was possible for them to return to their parents or to someone in the extended family, or not to be placed in foster family when possible, or in exceptional cases in adoption. Many hearings have been made. When the hearings were not possible, psychologists and social workers that work within the judiciary have made meetings with protection services to analyze the situation, and alternative solutions have been found for many of those children. However, there is still a concern because Brazil is still in a moment where the contamination is increasing. There is a concern with those institutions if it will be possible for them to continue functioning if the professionals get sick, or even the children, and if there is a lack of professionals to work. So this joint recommendation has also considered emergency measures like provisional foster care by provisional foster care system by the professionals working in the institutions. They would take care of the child during this contamination period. This is just an emergency solution, but if case the capacity of the service is compromised by COVID-19 contaminations. One of the main issues in this period was to grant access to justice for children, as the courts were closed as much as other institutions of the judicial system, creating difficulties to be reached, especially by poor people. We had also a challenge to organize the system because other institutions were not aware of how they were going to work. So we have judges. Most of the judges have created local WhatsApp groups with the protection services to grant easy access between communication tools, between all of the professionals to solve doubts about how the interaction would be done between the institutions in case of child protection during this isolation period, and how emergency face-to-face contact with the children when needed would be done. Protection services and police are the front line of these activities. They are receiving the reports of rights violation regarding children, women, elderly people, and other vulnerable groups, and sending these reports to the public prosecutor or to a public defender. Public defenders have organized a platform to provide a WhatsApp number in their website for the population to ask for legal support. Since May the 4th, there is no more suspension of procedural acts and deadlines. We are able to work in a relative normal way, but always remote. But there is still a challenge that a large number of people do not have easy access to internet or expertise to use technological tools. More than that, one important issue is how to grant child participation in a remote way. In which situations is it acceptable that a child participates in remote hearings, especially when we are considering situations of violence? We consider that the children should only participate when they are already protected in a neutral place. Therefore, this interaction with protection services were very important to analyze which were the alternatives that we could provide for children. And after these previous evaluations, when professionals from the judiciary, like psychologists and social workers, have also intervened, we have organized and we are doing hearings with the children if the family have the capacity to access to internet. If they are in institutions, this will be provided by the institutions. So we are in a certain way given precedence to urgent cases, because we consider that although it's possible to move forward all files in this moment, it's important that the urgent ones have more attention, and we are trying to do that with Microsoft Teams, as in Albania, and it has been working until the moment. That's all my first considerations. Thanks.
Thank you so much, Judge Melo. Now we'll head over to Japan and hear from Mikiko Otani-san.
Thank you. Because the basic measures taken by the Japanese family courts are very similar to other jurisdictions, I just want to highlight maybe 2 points, which are some features in Japan. First one is in Japan, there are 50 family courts throughout Japan. In principle, 1 family court in 1 prefecture. Because the government declared the state of emergency only for 7 prefectures at the beginning and expanded to all 47 prefectures later and extended for all prefectures again. But on 15th of May, the state of emergency declaration was lifted for 39 prefectures. And we are mostly going back to the lift of all the lift of state emergency for all prefectures. So the level of the measures the courts have taken is different from the prefecture to prefecture or from court to court, depending on whether this prefecture is under the state of emergency or not. However, the basic measure is like other jurisdictions, suspension of the hearings, but for exceptions of the urgent matters. The urgent matter cases include hearings of domestic violence protection order, child custody cases of special urgent matters, cases of placement of children in the temporary custody, so on and so forth. But one feature I should share with you is that in Japan, although each court has taken the decision on the measures for this situation, but the Supreme Court of Japan adopted the business continuity plan in 2016 before the COVID-19 situation. The development and adoption of the business continuity plan by the Supreme Court was in response to 2009 new flu pandemic. So this plan already existed and was publicized on the Supreme Court website. This plan applies to all the district and family courts in Japan, but encourages each court to develop their own plans, taking into account of the respective situation of the courts and the local situations. So the pre-existence of such business continuity plan already by the Supreme Court was the basis for the decision of each court in Japan in this COVID-19 situations. Another point I just want to highlight about the Japanese situation is that also online participation in the hearing is allowed for certain situations, but it didn't work so much because sometimes the court didn't have enough capacities or the availability of the technological facilities. And also this online participation is not helpful for the parties who are not represented by the lawyers. Final point I just want to raise is that now that the declaration of state of emergency has been lifted in almost prefectures, with the possibility of lifting for all remaining prefectures we are entering into the new situation on how to keep operations of the courts while ensuring the safety of all involved in the court system. And backlog is one concern. And another big concern in Japan is how to create physical distance in the mediation, which is the essential feature of the Japanese family court system. For example, it is mandatory for the parties for the divorce cases to go through mediation. So the family court mediation, which is called conciliation in Japan, costs little, is very easy to access and use for parties without lawyers, and conducted by 2 family matters conciliators, sometimes with a judge, court investigation officer, or clerk in the very small or rather small conciliation rooms in the family court buildings. So ensuring the prevention of infection is a serious concern for the parties, family lawyers, and conciliators or mediators. Thank you very much.
Thank you so much, Otani-san. And now let's hear from Australia. Over to you, Justice Ryan.
One of the advantages of being an island at the end of the world is that we can see what is unfolding in other parts of the world before it arrived here. And so it has been with COVID and the courts. So we had the advantage of being able to watch and react with the benefit of experience of other jurisdictions. And the decision was taken immediately once it was clear that we too needed to address the reality of COVID, was that the court must stay open. The question for how to continue to operate, though, was the more complicated question, because the government, like those that we've heard from already, said everybody had to go home, and we knew we were going into a period of lockdown. We were fairly fortunate that there has been reasonable investment in infrastructure, in technology, and in training of the judiciary and the staff. And so we were able to pack up and go home appropriately equipped with what was going to be needed to be an online environment. We were well advanced with a digital court file, lawyers, judges, court staff. We were well used to electronic filing, electronic forms, electronic court files. I haven't used, for example, a paper file in my work for at least 2 years, I suspect. So the decision, when we knew we had to go completely online for a reasonable number of the players, it wasn't a hugely dramatic step in terms of the way we at least would manage the evidence that had been filed. We closed the registries to walk-ins. People were not able to come to the counter. An appointment could be made to see a member of the court staff. I'm not sure that anyone has needed to do that. We banned all over-the-counter filings, for example. So everything was to be done electronically through the court's portal, other than by specific prior arrangement. And it has worked well. We had a period, I think, of about a week where cases were being adjourned, really while we were all working out how are we going to respond to a changed environment when we had no idea how long this change was to last. And there was a great deal of activity with judges, court staff reviewing files to decide what had to proceed and what could be adjourned. But during the period since then, or throughout actually, none of the appeals court hearings have been adjourned. We have continued. Every case that was listed has been heard. The same applies to divorces. The conciliation conferences have been proceeding. The duty lists have been proceeding. And a lot of the trials have proceeded. Where the trials haven't proceeded, that's been more a decision by the litigants and the lawyers than it has been by the court. Like Brazil and Albania, we chose Microsoft Teams as our platform for doing our work online. That reflects the decision by our IT people that provided the greatest degree of security. We already had a call centre, and that has been essential in enabling the community, including the legal profession, to cope with the fact that the doors to the buildings were in effect closed. The call centre provides live chat services so that if a person is having difficulty managing filing a document, accessing the court file online, they have a live chat conversation. It's a very effective tool, which we didn't anticipate, I don't think, that we would need something like this to the extent that we have, but it's been really critical in our ability to keep functioning. I think we recognise that the dialogue, we needed to have a really solid dialogue with our legislators, with community service groups, with the profession, in order to help us stay in touch and them stay in touch with us. We needed to think about new ways for witnessing documents, for what would we accept with an electronic signature, what would we accept in a document that previously would have required a person to swear to the truth of a document. All that, we realised that all that would do is put the person swearing the document in close contact with the person taking the oath or affirmation, which would be inconsistent with social distancing. So we proceeded on the basis that no assumptions could be unchallenged. And so we just opened up the documents can now be signed by parties with and affirmed, but without them needing to be physically present with the person taking the oath and affirmation. We've been pleasantly surprised by the skill evident in the litigants in person. So there hasn't been a distinction, as far as we have seen, about litigants who are appearing without a lawyer and those who are appearing with lawyers in terms of their ability to cope with the online environment. It may be that they are well schooled in advance, because in advance of the hearings, the court is in contact with the litigants and the lawyers, and they're doing trial runs with them to make sure that they understand how to do teams. I suspect they need to do more trial runs with the judges and the litigants, but anyway, they've managed to make all of that work very well indeed. I'll talk a little bit later about urgent cases, because we have established a specialist COVID list, which is really responsive to the fact that borders are closed, internal borders are closed, the borders to the country are closed, contact centres are closed, and as everybody has recognised from your individual experiences, this is a time when there is a heightened risk of family violence. evident from when Hubei shut down. It's reflected in the data that's coming through now, and we've seen a 40% increase in filings in our court for urgent assistance.
Justice Ryan, thank you so much for sharing those reflections, and also some of the hinting to some of the challenges. To the panelists, what I'm going to do is move to the final question. As many of you have discussed some of the challenges, pointed to some of the challenges during your when you spoke, and we'll also collect that information and document it and share it with partners. But perhaps I can ask you each to reflect very succinctly, given we only have about 20 minutes remaining, that the COVID-19 pandemic has taken us into uncharted territory, which many of you have emphasized, and many countries are learning on the go, learning as they do, including the courts. And it's highlighted, it has been challenging, but it has also highlighted ways of doing things differently. And some of you have highlighted those ways today. I wonder if you could perhaps just reflect on how can we ensure that after the pandemic has passed, some of these gains that we have made can be continued and are not lost. So perhaps let's begin with Canada, with Justice Gagnon, for your reflections.
Yes, so I will combine question 3 and 4. And briefly, I would say that one thing that has been working and I think should be put forward is the collaboration. That is very important. And I think the judge from Australia just told us that it's very important that all the stakeholders work together. So in small regions, I felt that was really a good thing, because very quickly messages could be sent by our Youth Affair Committee to other lawyers, to court clerks. So we would work together. So we were capable to adapt quickly to the situation and put all this web RTC and team video conference. We could use them quickly. So I think this is something that we have to remember, that a youth committee is something that is on the go, always looking where are the problems, how we can find a solution is good. And this we had before, so it was easier for us to cope with the situation. One other thing is that it brought the lawyers to talk together better, to find compromise, because they wanted to have a decision from the court. And if they would agree on things, we would accept to use their draft agreement as a decision. So they work more together at making a compromise and provide the court with agreements that would allow the case to move forward towards services instead of being on the docket and postpone and postpone. And I hope this we will keep, because this is the spirit of the law, to try to work together, make compromise, and have people join into agreements. So I'm very happy if this can last. Also, we were very preoccupied, as said the Judge of Australia, that the domestic violence was increasing and the children were not seen anymore, because they were in their family, in their house. They were not going to school, not to kindergarten, no security net around them. And we saw the reports decreasing. We knew it was not going well. The reports were decreasing at the youth protection. So the youth protection sent flyers everywhere in the house, did publicity on TV and on radio to alert the people, to sensitize them, to be aware. And if they could report children's situation, in doubt, it was better to be safe than sorry. So this, I thought, was providing some kind of sensitization to the public, to make sure that we were taking care of our children during this time. They were with their parents and sometimes neglected or abused. So these are the things I think that are good, and we will never give up courtroom, because this is a good place sometimes to solve problems, and we need to be together. But I think we will keep the video conference, because not everybody has to be in court all the time, and we will save time, and people will be more, lawyers and social workers will be capable to be more with their clients on the ground, helping them, instead of waiting for hours in the courtroom, which is definitely not a good thing. So that is what I had to say.
Thank you so much, Justice Gagnon, and for providing such a good overview and wrap up there. Perhaps now I will turn to Albania, to Deputy Minister and Mr. Muharremai. If you could perhaps give a very short reflection on how we can ensure we don't lose these gains. Thank you.
Thank you. One of the new novelties that we have tried to use during the pandemic was giving free legal aid online. As I mentioned shortly in my presentation, the Ministry of Justice has also decreed, also the government, a new system of legal aid that offers primary legal aid in terms of administrative procedures, counseling, and secondary legal aid, that is the legal aid to go to court and also to claim a petition before the court. During the pandemic, since everything was in lockdown, we established that we will create a special department with 11 lawyers that would provide online services, online counseling to people in need. And we had different applications, not only dealing with domestic abuse, but also child protection, child parenting, property issues from different vulnerable groups who came and also are eligible for attaining free legal aid. We think that this is a good practice because sometimes due to cost of transportation or sometimes due to lack of trust in the institutions, people might refuse to take a long path to approach any institution in terms of having legal aid. But by having a smartphone, or a phone, you can in our hotline number or write to us in our online platform, and you get a lawyer with whom to talk. And this was a platform and also on hotline, which were not only published in the website of the ministry and also in our social media, but was also broadcasted in TV. So everyone could get the information about the hotlines or the platform, online platform. And we think that this is a good practice which we should proceed on.
Thank you so much, Deputy Minister. Over to you, Mr. Muharremai.
Thank you very much. I'd like to look on the brighter side of the issue. As the saying goes, every cloud has a silver lining. So this situation has brought about possibilities to hold the online hearings and even move the judges themselves from their strict positions where they so far required to have the children testifying in the court to require their physical presence in the courtroom. I apologize to the honorable judges, part of the panel, but in my opinion, courts are rather conservative by their very nature, and they are in their ivory tower and they feel safe within that environment. But this is really an opportunity that even after the pandemic ends, and I hope that it will happen soon, these positive developments will be kept and move on further from this moment onwards. Of course, I had one question as well from one of the participants, and I replied in writing. But I'll mention again that this is an opportunity, and we have been discussing in the Council for possible legal changes. We will bring forward, we will put forward to the Ministry of Justice a proposal by the Council to make legal amendments to the codes of civil procedure and criminal procedure in order to allow for remote hearings. And of course, I see children as beneficiaries of such a practice. And another positive development that I would mention is that the pandemic has made everyone, including judges, to have a deeper appreciation of both physical and mental health, including that of children that are in conflict with the law. So in the context of justice for children, this means that the attention to the best interest of the child is getting an even more prominent role during the pandemic, compared to the public interest of ensuring legal accountability and the fight against criminality. Most probably, this is what is motivating judges to apply more non-custodial rather than custodial measures, something that is also highlighted in the UNICEF's technical note on children deprived of liberty and COVID-19. So I hope that with this new appreciation, even after the pandemic, the courts will continue to internalize and uphold the centrality and prevalence of the principle of the best interest of the child. Thank you.
Thank you so much, Mr. Muharrem, and I'm sure that the panelist didn't take any offense. This has indeed taken us into uncharted territory, and we are all learning. So let me turn to Japan and Mikiko Otani-san, your reflections on how we can move forward.
Thank you very much. I have three quick observations. And firstly, previous speakers already pointed out that we need to work together. Access to justice involved many institutions and stakeholders. Courts, of course, lawyers, legal aid. And I'd like to highlight the role of bar associations. Currently, the over 60 bar associations all over the world have been sharing the information and experiences. So the court to courts or judge to judges information sharing is very important across countries, and bar associations are doing the same. So maybe each sector can document and learn each other the good practices and bring back to the local community and work together, such as developing the business continuity plan involving all the stakeholders, but also paying specific attention to the parties who are not represented by the lawyers, because for many family court cases, there are the cases that the parties are not represented by the lawyers. So how to respond to solve those cases in the situation such as pandemic. Second point is access to just the use of alternative dispute resolutions. In Japan, we have experienced a lot of disasters, such as big earthquake or typhoons and Fukushima situations. In response to such large disaster situations, we have developed and promoted the use of alternative dispute resolutions for such specific situations. Of course, we should work together to keep court operating, but at the same time, alternative dispute resolutions outside the court, which is accessible, affordable, and faster, could be also useful tool to ensure the access to justice for women and children. The third one is, I think in the long run, the lessons learned from the experience under the current pandemic should be integrated in our access to justice agenda and work globally, but also in each country. In this regard, I just want to highlight that Sustainable Development Goal 16 calls on every country to provide access to justice for all and build effective, accountable, and inclusive institutions at all levels. So continued functioning of the court system, even in the emergency situation caused by pandemic or natural disasters, is fundamental to maintain access to justice. And to provide access to justice for all, children and women's special pre-existing and additional obstacles to access to justice and particular needs due to emergency situations should receive increased attention. And I think this angle should be integrated in our work for the SDGs. Thank you.
Thank you so much, Otani-san. And let's head over to Brazil to hear from Judge Melo.
So I'll try to combine as well the two questions. I would begin with a question, what means being operational? It's not only the internal work of the justice system as a protective system for children, which I must say it was not difficult to organize when we are just talking about dealing with prosecutors and lawyers, but we have to structure it and to think how we are organizing the whole system. If one of part of this system fails in its operational goals, anything will work. And we are all concerned in Brazil as well with the increase of violence that children may be experiencing in this period of isolation, but some numbers show a decrease in the reports of violence. And if in normal times children have, as already exposed, access to a variety of settings, now more than ever, we are seeing that we are not close enough to children, that they don't know how clearly the ways to get the support, and a situation which is even worse in middle income countries like Brazil, where, as I said, there is no access to internet or even cell phones by children. So I think there is an issue of social rights on one hand. On the other hand, how we could provide better sensitive tools like child-friendly websites and communication with the community. We have also sent flyers to the social media to the community. We're counting with the community. Judges are participating in a variety of ways in the social media with other services, explaining the increased risk of violence against children in this period and how we can support them, how the justice system is working, and how it is important for the child to be confident that in spite of the distance, we are able to help them, to grant a rights and to provide assistance. So I would say that one thing that we have gained in this period is that we can work faster than we are used to. We are working much faster in these urgent situation cases than we do normally, because distance is not a limit anymore. We were already using video conferencing. I think we're going to use it much more from now on. And we also discovering new tools to facilitate the access to the justice systems and the interaction between parties and services. It's also patent in my point of view that we are late in providing better alternatives for children, both when deprived of parental care and in juvenile justice. We have provided these alternatives in this moment, like in Albania, and I think people maybe get conscious that it's possible to use alternative measures more widely than we have used until the moment, respecting the juveniles and using deprivation of liberty as a last resort. I think the second lesson learned is the importance of dialogue, of proximity, openness to new solutions and creativity. We have a tradition of proximity with the network in Brazil. We focus ourselves, the justice system, as a part of a broad system to protect children. And I think this proximity will increase, contributing to enhance opportunities for dialogue in the future. But I would like, as a member of the association, also highlight the recognition that it's very important for us in the justice system to be together, to experience this necessity of proximity between professionals in different areas from different parts of the world, and would like once again to thank UNICEF for this partnership, because I agree with Albania that justice is very conservative based on traditions, but we are also understanding that it's possible to keep tradition with creativity, with new solutions. And the specialized justice system has a tradition of renovation. And this renovation has been created through international dialogue. And I'm very pleased to be in this moment representing the association with Liz and with UNICEF, offering judges and legal professionals around the world the opportunity of this dialogue. And we hope this proximity will remain and increase, and we'll do a better job in the future. Thank you very much for this opportunity of being with you in this webinar.
Thank you so much, Judge Mello. And let's now head to Justice Ryan for your closing reflections at the end of this webinar. Thanks, Justice Ryan.
been said by my colleagues' closing remarks, and I won't repeat the sentiments. So I just leave you with a couple of ideas. We have been conducting user surveys as we have unfolded new processes to receive feedback about what is working and what is not, and it's enabled us to respond and change and improve as we go along. And I think that's been a very useful tool. I was one of the judges, and I think we were all very concerned about how we could move into an electronic online platform and still adhere to the principles of open justice, because that's a fundamental concept that's dear to our hearts. And if a person comes into the courtroom, they can come into the courtroom, and we were trying to understand how could we manage this in the online setting. So we have on our websites notice that anybody who wants to listen into a court hearing is able to contact the court. We control who are the participants, but we have been able to maintain open justice. I think we've learned, again, a message that is familiar to all family lawyers, the importance of triage, being able to identify and respond very quickly to urgent cases. We're in a climate of urgent cases, and in the development of our COVID list, we've designed a model which is focused, responsive, and ensures that people are before a judge within 72 hours. It's a model that has a lot to offer going forward. And I think there is a mood that I sense, at least, that we are all in this together. And it's a very positive mood driven by extreme circumstances, but I think it's helped recalibrate the dialogues that we have in our own community between people who are seeking justice, people who are providing it, legislators who are designing systems of justice. And I am dearly hopeful that we together can be strong and achieve really good things and strip away processes and attitudes which are no longer current or relevant. And I hope that that's the mood that takes us forward, at least for the rest of my judicial career.
Thank you so much, Justice Ryan. And ladies and gentlemen, we've come to the end of today's webinar. I'd like to offer my deep thanks to each of our panelists today. And I would also like to express thanks on behalf of UNICEF to the International Association of Youth and Family Judges and Magistrates for this partnership to organize these webinars. As all of the panelists have highlighted, sharing experiences across countries that are very different in many ways, but we see many common elements that we can all learn from each other. And if this pandemic has taught us anything, it is that we are all in the same world, in the same boat, and that we can rely on each other to learn and achieve the best for children and for women and for humanity. As mentioned, we have recorded this webinar and it will be uploaded online, and we will share details as soon as that is available. So with that, let me wish you all a lovely day, afternoon, evening, and thank you once again.